Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and today I want to talk about red flag laws. Are they constitutional? And are they going to solve any of the problems that they intend to address? Let's talk about it. In the years since Florida enacted its red flag law, Kendra Paris has defended nearly 20 clients against risk protection orders that could remove their firearms. This Orlando-based attorney has long represented people who might be subject to the state's involuntary mental health treatment provision. But when this new law, meant to protect against people who might be a harm to themselves or others, passed in the aftermath of the February 2018 Parkland mass shooting, she saw yet another opportunity for the state to potentially deprive certain people of their civil liberties. Since the law's adoption, Florida courts have approved around 2,500 risk protection orders, according to an August count by National Public Radio. Since Parkland, at least 6 states and the District of Columbia have passed red flag laws, which allow enforcement agencies that have received a court order to remove guns from people considered a harm to themselves or others. In the wake of high-profile shootings this summer in Ohio and Texas, including one that killed 8 people in Midland, Odessa this past weekend, more state lawmakers are considering such laws, as are some members of Congress. Many law enforcement officials firmly believe the laws save lives, and lawmakers say that they can craft legislation that won't infringe on civil liberties. But for 2 decades since the first such law was enacted in Connecticut, civil and gun right advocates have protested that the seizure violates the U.S. Constitution's due process guarantees, meaning residents have a right to fully argue their case in court. Rather than find clear and convincing evidence, courts are basically saying, "Better safe than sorry," Paris said. Most red flag laws are vague on what constitutes a significant danger, which gives courts broad discretion to seize firearms. And in some states, respondents are not guaranteed representation in court, since these are civil and not criminal matters. Many defense lawyers say respondents fare much better with legal representation. 7 cases that Paris has represented people on have gone to a hearing. She has won 5, which she said is a vastly higher success record than when someone represents themselves. There are due process concerns. 17 states and the District of Columbia have laws on the books that allow law enforcement or family members to petition courts to remove weapons from people who may be dangerous and prevent them from buying other weapons for up to a year. In many of these states, bipartisan groups of lawmakers led the drive to pass the legislation. States define red flags differently, but they largely follow the same process for taking away somebody's guns. If somebody is showing signs of erratic behavior or express some intent to hurt themselves or others, they might be subject to an extreme risk protection order. In most states with red flag laws, family or community members can petition a court for these orders. But in Florida, for example, Rhode Island and Vermont, law enforcement officials are the only ones who can petition to remove firearms. If there is an immediate risk of harm, a court can issue a temporary ex parte order to seize guns from people for up to 14 days in most states. Other states range from 2 days to 45 days. At those hearings, a judge can issue an order by listening to evidence from the petitioner. In many cases, however, the subject of the petition can't present a defense until the final hearing. But that's where the process gets legally dubious, according to most critics. Dave Kopel, research director at the Independence Institute, a Denver-based libertarian think tank, said states have taken the same approach President Donald Trump spoke in favor of in March of 2008. Take the guns first, go through due process second. When it comes to seizing guns through a temporary order, the standard that a judge uses should be high, according to Kopel. Vermont, he believes, has a fair system, which requires specific facts that show an immediate and extreme risk. The situation becomes even more precarious when loved ones can petition the removal of firearms, he said. Spurned former partners or family members seeking revenge might weaponize this tool, he alleges. Because of that, he argues there should be a penalty for maliciously false accusations, which several states have adopted. New York State Senator Brian Kavanaugh, a Democrat and the author of the state's red flag law that went into effect last month, said family members and former partners are most likely to have the evidence and an urgent need for safety. The Empire State even added school officials to the long list of potential petitioners. The New York law requires enough due process, he says, including an appeal process, a prompt evidentiary hearing, and a burden of the petitioner to meet a certain standard of evidence. He believes that they have struck the balance just right. This is the government depriving people of their property. When you do that, you have to be careful. And we think we have, according to him. In some states, lawmakers modified legislation to address due process concerns before the final votes. In Rhode Island, the American Civil Liberties Union originally came out against the state's 2018 measure until the legislature tightened the standard for granting a petition, created penalties for providing false evidence of a threat, allowing only law enforcement to file petitions, required specific evidence, and granted the right to legal counsel in hearings. After these changes, the group shifted its stance to neutral on the bill, dropping its main objective, according to the Rhode Island ACLU Executive Director, Steve Brown. We believe it's very important that basic due process standards are considered when drafting measures like this. It can have serious impact on innocent individuals. Still, some gun rights activists reject the laws flat out. Mark Panak, president of Maryland Shall Issue, a gun right group that has opposed many of the recent gun control measures adopted in the state, including a ban on bump stocks and red flag laws, and he's concerned about future abuses, including officers taking away guns just to be sure. My concerns have gotten worse, Panak said. People are being legally traumatized. Red flag laws have emerged as one of the most common responses to mass shootings across the country in recent years. At least 5 more states, including deeply red Kentucky, have bipartisan bills under consideration. Polls show that Americans widely support the policy, even by as much as 77%, according to an August poll by American Public Media Research Lab. While it's difficult to know how many shootings might have been prevented through these court orders, news reports and around the nation show that courts and local law enforcement agencies have been able to use the laws thousands of times. Law enforcement officials have been clear. Many think these laws are saving lives. For decades, Pinellas County Sheriff Bob Gualtieri and other Florida enforcement officials would encounter people whose behavior didn't rise to the level of a crime, but who showed signs that they might be a threat. There was nothing in the state law, he said in an interview, that would have allowed law enforcement to remove guns or ammunition from a potentially dangerous home until March of 2018, when Florida enacted its red flag law. Now we can do something in those situations, he said. Between March of 2018 and March 2019, courts granted 233 risk protection orders in Pinellas counties, according to state data. In that period, courts denied only 1. Gualtieri rejects some of the criticism over due process. The standard for removing weapons is high, he claims, and requires clear and convincing evidence. His department has a 5-person team dedicated solely to risk protection orders. And when court issues temporary orders, it's only for a brief period, he alleges, and builds on existing laws of civil domestic violence restraining and protection orders. He claims there is no perfect law. It doesn't exist. We're in a much better place to make sure the guns are not in the wrong hands. There's nothing worse than a horrific situation that could have been avoided. Now, red flag laws continue to enjoy nationwide momentum. After 3 mass shootings last month in Dayton, Ohio, in El Paso, and Midland, Odessa, Texas, left at least 39 people dead, state and national leaders are once again hearing a chorus for action to prevent future gun violence. U.S. Senator Lindsey Graham, a South Carolina Republican, announced his intention last month to introduce bipartisan legislation with Democrat U.S. Senator Richard Blumenthal of Connecticut. It would set up grant programs to assist states in adopting red flag laws. Local law enforcement agencies could use those funds to hire and consult mental health professionals before issuing extreme risk protection orders. But Graham, chairman of the U.S. Senate Judiciary Committee, made sure to mention that new legislation would require robust due process and judicial review. Red flags have survived two major legal challenges. In one case, the Connecticut Appellate Court found in 2016 that the state's red flag law does not implicate the Second Amendment, as it does not restrict the right of law-abiding, responsible citizens to use arms in defense of their homes. Since the Second Amendment was the focus in both cases, said Kopel of the Independence Institute, there's still room to address due process. In Florida, Kendra Paris has a case in State District Court of Appeals where she is defending a 16-year-old boy with autism who threatened to shoot his classmates after becoming agitated in class when a peer kept bumping into his desk. School authorities notified local law enforcement, who later secured a temporary ex parte protection order. In the process, Paris is arguing the boy's constitutional rights were violated. Paris is citing the law's vague language, due process gaps, and separation of power issues. Law enforcement both conducted the investigation and decided whether the case should go to hearing. She thinks her case, which goes to oral arguments in October, might eventually make its way up to the Florida Supreme Court. These emergency protection issues are the buzzword of the day. There are lots of legal implications to this because it does affect potentially one's civil liberties. To have their property taken away from them requires due process, and that's where it gets tricky. We're not saying that these are perfect. We're not saying they're right. We're not saying they're wrong. We're just simply saying, let's talk about it.